To my left in the house, I have Super Attorney Rick Dodd. And Rick, it's always a pleasure to have you. And in case you don't know it, Rick Dodd is the part of the Coppolino Dodd Krebs law firm that helps sponsors this long segment. And we couldn't be on the air without him and all of our other sponsors. So we want to thank these guys and thank all of our other sponsors as well. And remember to support them and as much as you can. Rick, we've been doing the Bill of Rights, going over the 10 Bill of Rights. And Ross has been in and done, I think, 6 of them?
At least.
7 of them. And now you're in to do your favorite, which is the 7th Amendment.
Yeah, I enjoy doing the 4th Amendment, but the 7th is definitely my favorite because it's the kind of law I practice, the jury trials.
Well, it makes sense. So you must know it inside and out.
Well, there's not much to it. What the courts have determined is that it's pretty self-explanatory. Have you read it for us?
You know what's funny? You say it's self-explanatory, and I was reading and I go, I need questions on this, this, and this, because I'm not sure of it. So no, it's not self-explanatory, Judge. I need an explanation. So that's why Rick's here. He's going to help us out. I'm going to read to you. First, before I do that, Rick, I'd like to read the preamble to the Bill of Rights. A lot of people didn't know that was there. And the preamble to the Bill of Rights is just an insurance policy to make sure that nothing's misconstrued and that they understand clearly what these rights are about. So
well, the history of that preamble also has to do with the Federalist and the Anti-Federalist. The Federalists, of course, wanted to adopt the Constitution as it was. The Anti-Federalists were concerned that it would take away states' rights. So the Federalists then decided that if we come up with these 10 Bill of Rights to guarantee that the federal government won't overstep their bounds, we can get it passed, which they were successful in doing.
okay, very good. Good explanation. Let me read what it says. Congress of the United States begun and held at the City of New York on Wednesday, the 4th of March, 1789. The conventions of a number of the states having at the time of their adopting the Constitution expressed a desire, in order to prevent misconstruction or abuse of its powers, that further declaratory and restrictive clauses should be added, and as extending the ground of public confidence in the government will best ensure the beneficent ends of its institution. And then let me read to you the 7th Amendment. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. So that's the 7th Amendment. And Rick, I got questions just because of terminology and phrasing that would need clarification. You want to go over those real quick?
Well, basically what you got is the 7th Amendment is it guarantees the right to a jury trial. And that's what's really important for us to consider. And let me talk a little bit about it before you ask questions.
Okay.
And it's like the first generations of Americans believed that this right was so important that they didn't want to pass the Constitution as it was without it. There were actually 12 amendments that were placed in front of the states, and many of the states didn't adopt but 11, and some didn't adopt the same one.
Mm-hmm.
Okay. Yeah. So it left us with 10 amendments that were adopted by, I think, 75% of the states. During the process, Vermont got named as a state, so it caused us to actually have 2 more. So I think the last ones to adopt them were Delaware and New York. So that's where we get the 10 amendments. But they were absolutely requiring the 7th Amendment, the one for a jury trial. And the reason for that is because leading up to the American Revolution, here in America, we didn't have a right to a jury trial. Now, John Wilkes back in London, he wrote some stuff that was not very flowery for the Crown.
You know, you're saying that now. I can't believe that would happen back then. It's against your nature, or is it because we're Americans with these rights now that we were so opposed to that thought process?
Well, we weren't in charge then. The Crown was in charge.
Yeah, I guess you're right, yeah.
So, it all has to do with who's in power. Okay. And the Crown was in power, but he was losing some of his power.
Thank you.
Basically, there was a parliament, and the people had decided that they had the right to behead some of their leaders. And, the Crown didn't want that to happen, obviously.
That's right.
So he was willing to give up a little bit of his power. So when the jury trial came along and John Wilkes had written his stuff that was sort of against the Crown, the jury actually acquitted him, and that decision was applauded on both sides of the Atlantic, not just here in America. But we didn't have that right. So as you recall, the taxation without representation came up, the Tea Party happened, and then when the revolution came along and we started to adopt, we wanted the right to a jury trial. So they had that opportunity to go against what the English government had when they tried to enforce this Stamp Act, and they also hated the actions of Parliament when it came to criminal and civil actions. So they wanted that jury trial benefiting everybody in the United States. So what happened is in the new government, one representative of our new government pointed out that there no provision had been included for a right to a jury trial. This is when they were just talking about the naked Constitution, in other words, the one without the Bill of Rights. So they went ahead and put that in, and of course the majority of the delegates, I think it was unanimous, picked it up, and then all of the states that ratified also ratified the Seventh Amendment. So you had story about the Federalists that I just talked about, wanting it in order to go ahead and get the Constitution passed. They originally were against it. Then they found out that they might not get the whole thing passed, and then they were for it. And suddenly those that were against getting the Constitution decided they might be against the Bill of Rights, even though that's what they had wanted in the first place. So it's kind of one of those political mix-ups that makes a good story.
So what, a state that didn't want one right could have killed the whole thing of all the other rights?
Well, 75%. So you had to have 75% want all of the ones that were passed. In other words, if you had 100% wanting 8 of them, and then only 60% wanting another 1 or 2, and then a different 1 or 2 not being wanted by another part, then it might not pass those others. But 100% would, of course, got the 8. But you got to have 75 for each one.
Each one, okay.
Yeah. Yeah.
So it wasn't like a package deal, you either vote on this or not. It's one by one, percentage-wise, that gets accepted.
Yeah.
Okay.
Yeah. So what happens today is that there are people, mainly corporations, that are against the idea, and they're basically jury bashing, and you know, they're the same sort of wealthy and powerful special interests that our founders were warning us about when they passed it. In other words, people who could yield and wield power against us, you know, the common people that were out there trying to do the best we could with what we had. But if we had that special right for a jury trial, it's a rule of law, and the rule of law helps all Americans ensure our freedoms of expression, the sanctity of our contracts, the rights of workers out there, the safety of products and services, the preservation of our environment, and all the underpinnings of our great civil society. And you see, if you take any one of those away because the powerful are not in favor of it, and when I say powerful, I mean it's going to cost. If you have a corporation out there that's polluting our environment, there's a cost. And of course, it's going to be saving that corporation a certain amount of money, because instead of having to process their pollutants, they just dump them out on the ground. It runs down the creek.
See, but that's a grotesque way of making a profit. I understand there may be waste and spoilage and some type of pollution, but when there is no protection, like you're saying here, and they just have the free ability to do whatever they want, it grotesquely violates human and natural, just nature in itself. So I could see how that just has to be taken care of, you know?
Well, but when the bottom line for a being, and the Supreme Court of the United States has said that a corporation is a being, a person, if you may, you know, for freedom of speech, for instance, that's the big one that came out more recently. When the bottom line for them is to make a profit, you kind of wonder where the concept of grotesqueness stops. I mean, they are out to make that profit. That's the bottom line, and being gross is not a big concern for them. So that's why we have to have regulations. And of course, we hear the newspaper talk about terrible regulations, job-killing regulations, and we talk about, we hear it from the rich and the powerful. But you know, the regulations are necessary because of those sorts of actions. And fortunately, the jury trials will not only protect us as individuals, but it will protect those folks too. So if they get wrongly accused,
Is there a fair term? Is the term overregulation a fair term?
well, it depends on what side of the fence you're standing on. If you're standing on the side of the fence that's clean and pristine and you don't want the stuff running over on your side of the fence, then it's not. But if you're on the other side of the fence and you want to get rid of your stuff and let it run across to the other guy, then yeah, you're overregulated.
Yeah. Right.
I mean, that's true if you're driving a Lamborghini down the road, the speed limit suddenly changes to 40 miles an hour. You're thinking, man, I'm overregulated.
I'm paying too much for this car, man. I can't even go past 40 miles an hour.
So it depends on where you're sitting. I mean, the term overregulation.
I got a story about a Lamborghini. I'm in.
And it also depends on your beliefs. If you have a core belief that, such as I do, that, and it's based on what I believe to be lifelong experiences, that there is global warming and that it is caused by human activity, then you're going to be looking at some regulation and saying, well, that's great, that's wonderful. But if you're, on the other hand, you are solely concerned about economic development, then you want everything to burn and churn. So
What about the middle ground where we want economic development in a very smart manner that's not overburdening, that won't, because business has to thrive to a certain point, otherwise it collapses.
we all psychologically like to believe that we're fair and reasonable. If I stand up in front of a jury panel of 90 people and ask who's fair and reasonable, they're all going to raise their hand. It's going to be me, yeah. But then, Mr. Smith over here, he may be really hardcore against having any kind of, say, for instance, coloring on his windows in a car, whereas someone else over on the left, they may be happy to have limo covering on their car windows so nobody can see in. So it just depends on who's fair and reasonable. The middle ground, of course, is what we're after. That'd be the great thing, to have some sort of middle ground. But then again, the concepts of people's ideas about what is the middle ground changes and shifts, as do politicians trying to get our votes.
It's a twisted, messed up world. The web of lies, man.
Well, but it is what it is, and we have to work within the system.
Well, what's nice about it is that if it goes one way, we have the ability to say it's not working and try to do what it takes to get it changed through persuasion and information and votes.
Yeah.
So,
well, and talk about votes. Some of our duties as Americans is to protect our country and the military. And certainly everyone talks about voting as a duty of all Americans. Well, serving on a jury is also a duty for all Americans. And it is a patriotic duty. And without that opportunity, then you get overreaching by the rich and powerful. Without that opportunity, you get overreached by politicians who've been put in place by rich and powerful. But with the jury, you're able to go in, and normal folks can make a decision based on, the 6 or 12, depending on what kind of courthouse you're in. They can come together with their lifelong experiences and come up with a, hopefully, middle of the ground decision, as you talked about. Those that are against that concept, those who seek to undermine this institution that's fundamentally American, they distrust the American people. And what I mean by that, that's you and your family, your neighbors, your friends, your coworkers. Those people who go out and do their patriotic duty of serving on a jury are being distrusted by those who are trying to ramp down that system. So, anyway, having said all that.
You've known me for quite a while now, Rick, and I think you know where I come from on all this, and that is there are pillars that hold this country up in our way of life, and it's the Constitution and Bill of Rights. And if they get chipped away and eaten away and put to the side, I believe this country fails. I know this country will fail. So I'm very adamant and very stubborn and very protective of the Constitution and the Bill of Rights, to preserve them the way they were written. However, outside of that, preserving the goose allows us to have the eggs, and we can paint the eggs to different colors that we like or favor or get persuaded to do. So that's, ladies and gentlemen, I just wanted to make clear. That's the way I've always been. I wore a uniform to protect the Constitution, the Bill of Rights, and the way of American life. And the reason I have issues nowadays is because the Constitution and those rights are constantly being chipped away and trying to made altered or eliminated by a lot of people, in my opinion, that don't have a true core value or understanding of the American way of life. I think the American way of life is being diluted too quickly. A lot of people coming in from other areas don't understand the way this country was and built. And I say that because maintain America for what it is, protect it, and then those who come in to assimilate can bring their culture to and celebrate their culture there, but also remember that America comes first if you're here.
Yeah. Talk about celebrating cultures. I mean, all you have to do is go out to Myrick last part of August, and you'll see a culture being celebrated. But they have assimilated. I mean, they're a part of our society, and it's a wonderful thing.
I remember being raised in New York. Don't crucify me for that. But being raised in New York, I have Lebanese heritage.
And you saw all sorts of cultures. I mean,
But what it was, I remember my mom and dad. They would have the club, the Lebanon American Club, and they would have their foods and they'd speak their language. They'd play their games. But when they would go to parade, the banners on the side of the vehicles would say, "Thank you, America. God bless America." They put America first, and they just enjoyed their culture. The other way it is now, you got people coming here with their culture and wanting to push away the American way of life, and I can't tolerate that.
well, some of the things that have been happening in Texas as far as jury trials should and do give me great concern, and it should give everybody great concern. I mean, I can't sit here and go through them all, but basically, if I ask you to give me an example of a jury trial that went awry, in other words, something that just went wrong in the system, most people are going to point to the McDonald's case. And the facts of the McDonald's case are rather enlightening against the concept of limiting juries as opposed to
Can you enlighten
what
us on it?
McDonald's has done. And McDonald's, being the largest advertiser in the world, was able to get this story out that really messed everybody's mind up about what a jury trial is all about. And you got to remember that happened in 1992. Stella LeBay, I think she was 80 years old, retired school teacher, was a passenger in a car as opposed to being a driver. She got the coffee at the drive-through. Her son was driving, pulled over to the side of the road where she was going to pop the top off and put some sugar in it. It spilled in her crotch area and gave her third-degree burns. Her labia, ladies and gentlemen, was burned off. Stella had 3 different skin grafts. She had a total of about $200,000 in medical. Maybe it was $125,000. In any case, it was a substantial amount of money. A friend of mine, attorney out of Houston, took the case in, where was it? Albuquerque, New Mexico. That's where it was. Not necessarily a hotbed of liberalism, Albuquerque isn't. So they tried the case, and the jury heard that there had been over 500 different lawsuits against McDonald's, mostly for babies that were sitting, laid down in the chairs while somebody drank coffee at the table and spilled it on the baby. The jury learned that also that old people were affected by this because they aren't able to get away from hot stuff as quickly as maybe someone a little more agile. And Stella was really no different in that she had some serious injuries. She had contacted McDonald's and said, "Look, if you'll pay my medical, that'll be the end of it." And of course they refused. In fact, they got on the witness stand, McDonald's, some of their vice presidents got on the witness stand and said, "Well, we know that we serve our coffee about 10 degrees hotter than everybody else serves their coffee, but we do that so that the aroma will entice people to buy more coffee." So,
That did not sound good at all.
and they said, "Yeah, we're not going to change it. We're not going to do it. We're going to keep doing it this way. It's not our fault. It's her fault." And the jury didn't buy that. They may have given Stella some fault, but they went ahead and decided that Stella should get about $600,000 plus some punitive damages based on, I think, either 1 or 2 days worth of hot coffee sales for McDonald's, which was, I think, about $2.2 million, which is a substantial amount of money. But punitive damages are not to enhance Stella, it's to punish the wrongdoer. And if you're going to punish a wrongdoer that makes that kind of money, and you compare it maybe to like me getting a traffic ticket, well, let's give them a traffic ticket, and what might cost me, you know, $160 if I make, say, $50,000 a year, which should cost McDonald's a lot more than $2.2 million. So it really wasn't outrageous. But nonetheless, the trial judge eliminated those punitive damages right off the bat and gave a judgment to Stella for about $600,000. You don't hear any part of this story in McDonald's, because when they got the Wall Street Journal to print the story and everybody at Time, you know, they're all big corporations, so they went with McDonald's, who gives them a lot of money to advertise. Anyway,
It's a big vicious circle.
so well, it is, and it's, you know, you follow the money. But in any case, both sides appealed. You know, of course, Stella appealed because she didn't think the judge should have taken away the punitives, and McDonald's appealed because they didn't want to pay $600,000. And eventually, it was settled for a confidential amount, non-disclosed confidential amount. But it's, from good information, I think it probably settled for somewhere around what the verdict should have been, the 600. And after expenses and medical and attorney's fees, Stella would have wound up maybe with about maybe $150,000 for her burned off labia and 3 different skin grafts. So the real story is not something that we need to pound our chest over and go,
And
wow, we got to get rid of jury trials because they just run away.
Just a side note on that coffee. The hotter the coffee, the more bitter it gets. So I mean, you might want coffee a little bit less hot than that.
But it's not what you said earlier is
That's
important,
why
because
Sefco premium coffee tastes the
Fresh
same.
Joe,
Like
yeah.
Fresh Joe. Go ahead.
so it's not just attorneys like myself who practice trial law that have a concern about what's going on in Texas. I mean, what we see as wrong-headed activism now is being embraced by some of the Tea Party friends of ours. I mean, Tea Party activists are beginning to question whether the Texas Republicans have dismantled the 7th Amendment for us. They're beginning to question whether or not our Texas Supreme Court is going too far to the right. They're beginning to question some of the laws that our legislators are passing, which limits the right to jury trials. I mean, when I started practicing about 30 years ago, somewhere around 2.5–3% of civil actions were decided by juries. Today, it's less than 1%. It's about 0.75%. So if you look at that math, it's about a third of what it used to be. And when you look at 2.5%, it wasn't like there's a
How do
whole
you
bunch
get-
of them going on.
How do you get that way when it says clearly that you can't get that way?
Well,
Who allows it to happen when it gets down to 1%?
Well, one of the things that's happened is that the legislature keeps writing laws that limit our ability, and most of the folks out there really don't see these laws and understand. For instance, there's one where it's called paid or incurred. It used to be where if I got hurt and I went to my brother who was a doctor, I could ask my jury to award what would be a fair and reasonable amount for my medical bills. But now, with this new legislation, it's only what's paid or incurred. So, for instance, if someone's on Medicare and there's a $4,000 medical bill and Medicare only pays $400, then you only get to ask the jury for $400, which you have to pay Medicare back for. So there's no room for attorney's fees anymore. There's no room for any of that stuff. And all the money that was spent, millions of dollars to pass Proposition 13 here in Texas, not only limited our laws and allowed the legislature to put caps on things and shut down some of the 7th Amendment rights, but it also, in my opinion, poisoned the jury panel's mind. Today, particularly in car wreck cases, juries believe that if they were to award money, that eventually they're going to have to pay for it from themselves. And, you know, that's what insurance is all about.
Yes.
It's supposed to, you pay for insurance to take care of this sort of stuff. But juries today are so concerned about giving too much money that I see probably 95% of the car wreck cases that are tried in Texas result in absolutely no money for pain and suffering and no money for mental anguish.
Yeah, but isn't that based on the persuasion of an attorney in the courtroom saying, hey,
Well, it's based on the minds that are already poisoned by misinformation, like the McDonald's case. Again, when I stand up and ask people for examples of,
Yeah, I know, but wouldn't an attorney bring that up and say, "Hey, see,
Well,
they're trying to persuade the jury using examples"? Then a person like yourself would come in and try and say, "No, no, no, no."
But this is the fundamental thing about jury psychology is I cannot stand up and change anybody's mind in a 2-hour opportunity to speak to them in the voir dire. I can't convince them that their core values and core beliefs are wrong. So what I have to do is ride the wild pony. I have to go, oh yeah, there are way too many lawsuits, ladies and gentlemen. We know that, but this is not one of the frivolous ones that I represent, and that's the only way to do it according to the trial psychologist. Because if I try to convince them that Stella LeBay's case was genuine and that the concept that they have that there are too many lawsuits is wrong, then suddenly they look at me as just
Yeah, but
being
you know,
a liar.
Rick, I heard the side of that story of a woman who spilled coffee on herself and is now suing McDonald's for all this money. What a jerk, okay?
Yeah,
Here you explain the details, and I go, well, I get it, I understand it. I mean, it was severe burns. Yes, she's partially to blame, but there's also, why are you, the company makes it sound like they're so into profits, they don't care, they're jacking up the price because they're enticing you to buy more coffee. I can see that aspect of it too. So if you were to explain that to a jury, maybe that's persuasion right there.
well, again, they have core beliefs that there's too many lawsuits and that they give too much money, so they're just not going to do it. And where they get that is from companies, organizations like Texas for Lawsuit Reform. Now, they claim to be a grassroots organization. They claim they have over 15,000 members. And follow the money. Mm-hmm. They get 90% of their money from 6 different donors. And they have had a profound effect on jury trials in Texas. They have had a profound effect on the laws that the legislature has passed, limiting lawsuits, putting caps on lawsuits. And the Supreme Court that's been elected by the people who get advertising from Texas for Lawsuit Reform, millions of dollars, remember. They're up there embracing arbitration clauses. Now, you and I, we have arbitration clauses on our cell phones, on our credit cards. We have arbitration clauses on almost every contract that we sign these days, including employment contracts. So that if you go to work in some of the bigger corporations and you get hurt, you don't have work. They don't buy workers' compensation. They get you to sign an arbitration, and then they buy some sort of a quasi insurance policy that has a cap of either $300,000 or $500,000, and that's just about the limit of it. So you have to go to arbitration, which is fundamentally unfair, because if I'm going in front of an arbitrator whose job is to be an arbitrator, that person is probably going to come from a background of being very conservative, bankers, people who retired from big business. They go into arbitration, but they get chosen by ostensibly both parties, right?
It's like you're trying to pick your juror.
Well, if I go in there with Jim Bob Smith with a case for arbitration, that's going to be the only time Jim Bob's ever going to have to go to an arbitration, whereas AT&T, on the other hand, does it all the time. They pick arbitrators every day. So my middle-of-the-man arbitrator, guess who he's going to be leaning for? Because he wants that next job.
That's right.
Yeah.
Rick, time's ticking. I want to ask a question, though. I've had discussions with people, and some of their concerns are, I can't afford an attorney. I don't think they're aware that you may give the consultation for free.
Yeah.
You want to explain that? Tell people how they get a hold of you and
Well,
what you do and how they shouldn't be worried about anything up front if you're able to work something out, maybe?
Yeah, I mean, I do all of my cases and have pretty much for the last 35 years. On a contingency fee. In other words, we get a part of the recovery. And I'm happy to talk to people about cases because it's not always injury cases. It can be a contract case. We've handled oil and gas cases. We've handled some patent stuff regarding, well, not really patent stuff, but genetics, theft of proprietary interest in genetics. Some of the stuff is very scientific and gets rather complicated, but the bottom line is that people will come to us with their problems and their concerns about being harmed. If you've been harmed by another, in other words, another being a corporation or a car wreck or a truck wreck or a real estate transaction, we could help and sit and talk to you about it. And if we don't want your case, we'll tell you. If we don't think we can help you, we will let you know. if there are certain things in the law that say, no, I'm sorry you've been harmed, but guess what? Your right to a jury trial has been infringed, we'll tell you. But if we think we can help you and we take the case, we will front, the expenses. And some of these cases can be very expensive. For instance, I've had a couple of cases where we had $500,000 in expenses laying on the table as we were entering the courtroom. So a lot of people can't afford that kind of stuff.
Yeah, but
especially if you've been severely injured and you can't work.
Yeah, but a person who comes to you and you decide to do that, and you're just putting $500,000 on the table, ladies and gentlemen, they're going to work extremely hard for you. Okay?
Well, I mean, we're really proud of the jobs we do. We were, for instance, Newsweek named my firm one of the top 10 trial lawyer firms in the nation.
Wow.
So I was very proud of that. You talk about super lawyers. That we've been named super lawyers 4 or 5 different times. So we've worked hard. I mean, it's been done.
Well, tell everybody
we've done
how,
it.
tell
We
everybody
still
how
practice
to get a hold
it,
of
though.
you. And
Yeah, we can be looked at at respectforyou.com, RESPECT
okay.
for you.com. You can find us in Cameron. We are here, and if you don't know where we are, just ask somebody. But it's down on the same road that the 3 banks are on, 312 South Houston.
Rick, it's always a pleasure to have you on. Thank you very much. And,
Well, I wish I could have talked another 2 hours about the Seventh Amendment.
Well, maybe we can get you back on later, huh? Okay. All right, okay, let's go out with a quick break, and we'll come back in for enough time to get Delicious Janae on and get the chief up at right around 11:01. Okay, so we'll see you on the other side, everybody.
Thanks, everybody.
Very good.